Hello. We are joined today by Anita Allen, who is the Henry R. Silverman Professor of Law and Philosophy at the University of Pennsylvania. She is former president of the American Philosophical Association and an expert on philosophy of privacy, bioethics, legal philosophy, women's rights, and race relations. Welcome, Professor Allen.
Thank you very much. Nice to be with you, Michael.
Thank you. My first question for you is, as an academic philosopher, were there aspects of the Dobbs decision that you found especially interesting?
Absolutely. I think that in general, the abortion issue has fascinated philosophers since the early 1970s. As soon as Roe was decided, there began to be this whole series of conversations in the academy about whether or not there was in fact a moral right and a legal right to abortion. So I guess this is just a continuation of the fascination that we've all had with abortion since the beginning of this area of jurisprudence. But there were a couple of things that I found particularly interesting. One of them was something that I talked about when I gave a lecture on the Dobbs decision at the Blavatnik School of Government at Oxford last fall. And that is, I was fascinated by the way in which the case represents devolution in two different senses. In a legal sense, especially in the European context, devolution is when a higher level of government turns over authority for a certain realm of decision-making to a lower level of government. And so the Dobbs decision is a kind of devolution in the sense that it's the federal government through the courts giving power to the states. So it's devolution in that sense. But it's also devolution in another sense, a less happy sense, and that is it's a moving backwards, I think, in terms of people's, women's and men's, but families' fundamental rights. And in that sense, it's a devolution from what I would call the model of privacy as a abortion regime to a model of permission or prohibition. And let me just explain that a little bit more. For years, I have said there are four main models of abortion regulation visible in the world. The model of privacy, which used to be exemplified by the United States under Roe versus Wade and Canada primarily. And then the model of permission, which is the main approach in Europe, where women can easily get abortions, but they have to go before an official body or medical board or doctor, give their reasons for wanting the abortion, and then if those reasons are among the approved reasons, they can get the abortion. That's the model of permission. Model of privacy, by contrast, a woman can get an abortion without having to justify the abortion to anyone. The model of prohibition used to be the model in Ireland. Ireland's changed. Now the model of prohibition is very prevalent in Africa, in South America, but it's where the government flatly prohibits most or all abortions. And then the fourth model, I call the model of prescription, was a model whereby abortion was almost prescribed or required of folks. And the model of what China used to be no longer is, because now they discovered the one-child policy was a mistake. But the model of prescription meant that a woman who was pregnant and had already had a child might need to abort in order to avoid breaking the law and being fined or taxed or punished. So those were the four approaches. They all began with P: privacy, permission, prohibition, and prescription. Now, so the devolution that I see, that I found so fascinating, was this moving backward in the United States from the model of privacy to the model of permission, or even in some cases, prohibition, because some states are pretty much flatly prohibiting abortion if they can get away with it. Another interesting element to this case that I think philosophically interesting is all the discussion by Justice Alito in his opinion for the majority about this being a moral issue. It's a moral issue, and arguing that because it's a moral issue, it shouldn't belong in the hands of the Supreme Court. It should belong in the hands of the people and their democratically elected officials on the state level. But I find this very troubling, because it seems to me that if it's a moral issue, it might well require that we take it out of the hands of the general population and put it in the hands of those who are likely to give the individuals the kind of moral autonomy that they deserve as moral agents to make up their own minds about a morally difficult decision. So I don't think that it being a moral issue in any way points toward the outcome we got in the Dobbs decision.
I have a second question for you. What exactly is substantive due process, and why do America's privacy rights depend upon its continued legitimacy?
Okay, and so in order to dig into that juicy question, of which I thank you, uh, it's important to think about the total array of arguments that Justice Alito gave in the Dobbs decision. One argument he gave was that the abortion issue is not it's not textual. There's no right to abortion that's textually enumerated in the Constitution. He also argued that abortion is not an unenumerated fundamental right, because even if it were not enumerated, if it were fundamental, that would be great. That might be a basis for upholding a right to choose in the Roe versus Wade sense. But he argued that the two tests for fundamental rights are not satisfied by the abortion choice. First of all, he argues that abortion is not part of the nation's history and tradition, and nor, he argues, is it part of the concept of ordered liberty. I would disagree with both of those claims, but not right now. A third argument he made is that that while stare decisis, the idea that we stick to our past decisions as guidance, that while that's a valid concept, it's not valid where the decision is clearly erroneous, as he argues that the Roe decision was, based on the textual arguments and the fundamental rights argument. And then he argued that that the court should reject unworkable precedents, and argues that the Roe has proven to be an unworkable precedent. Again, I would disagree with that. I think that what's become unworkable is that some judges and some justices have decided that they don't want it to work and therefore it's not working. But on the ground, in terms of what services are delivered safely and equitably to American women, abortion is working very well, thank you. And then the final argument is that moral decisions like abortion are best left to the people and their state representatives. That was the one that I mentioned earlier. So, substantive due process. Professor Jim Fleming, who's a professor of law at Boston University, has written a whole book defending the idea of substantive due process. And he makes a number of excellent points in his book. But what I want to say about substantive due process is that it's simply the idea that the 14th Amendment, on its surface, protects Americans' rights to equal protection of the law and to due process under the law. And that the liberty language that's part of the due process clause is sometimes seen as opening the door to all kinds of freedoms being seen as constitutional values, including the right to birth control, the right to abortion, the right to marry a person of a different race, the right to travel, the right to not be sterilized, the right to, on and on, gay rights, including the right to marry and the right to consensual sex. So the due process clause has been interpreted to mean a lot more than just when you have your day in court, you'll be treated the same way everybody else is treated. It's been held to be a source of a right that the processes that are used to allocate rights and responsibilities and privileges also come with some substantive protections. So, so is this idea patently invalid? Is it patently wrong-headed? Well, some of the justices on our Supreme Court, including Justice Alito, Justice Clarence Thomas, and before them, Justice Scalia, have been very, very concerned about expanding rights through the substantive due process interpretation of the due process clause. Even some liberals, like John Hart Ely, have been skeptical of the constitutional jurisprudential validity of expansive substantive due process. Where do you draw a line between just deciding that whatever value the judge wants to vindicate as a value, whatever right the judge wants you have, that kind of, versus having some firm, clear principle upon which to judge right and wrong, and rights and wrongs. And my personal belief, and I think that my background in philosophy is actually relevant to this, because I think it's part of the notion that we are morally autonomous agents with with rights, including the right to make some critical decisions about our own lives ourselves and not be at the mercy of our neighbors or the government. And the substantive due process clause, for me, has a particular value in as much as it does kind of give us space within the Constitution for the realization of that idea. The 14th Amendment, as you know very well, but I'll remind your listeners and viewers, it was a post-Civil War amendment, and it was written, designed like the amendment that freed the slaves, the 13th Amendment, and the Voting Rights Amendment. These were amendments that were made to give people at the margins of society the same rights that everybody else has. And so one of the guidelines I think about when I think about how to interpret the 14th Amendment substantive due process idea is that, in principle, we want to give the people who are living at the margins of society, whether because they're gay or they're Black or they're female and poor, give them the same opportunities for enjoying the blessings of liberty that everybody else has. And so that's why I think that the substantive due process clause can be used on behalf of gay people, poor women in the case of abortion, and African Americans more broadly.
And do you think the reason that Alito and others did not see this is that they are blinded by white maleness, and they just don't see it, and when the Constitution doesn't speak about women and children, that it just they don't count as much, and that's why they see things that way?
I think it's partly a matter of some men not seeing the world the way I think it should be seen, which is to say through the lens of the dispossessed. But I think it's beyond that. I think it's also that some men and some women very, very consciously want to preserve a certain social order in which women are fundamentally at home, responsible for families and children. Even if they have careers come second. Those traditional home care and child care and housekeeping responsibilities come first. So you may have a Supreme Court justice who has many children herself, who thinks that that abortion is wrong. I don't think that's because she's blind. I think it's because she wants to preserve a certain vision of social life that works for her and her family, but doesn't work for millions of other families who turn to the abortion right as a way to manage their sex lives and to manage their the consequences of their sex lives and to manage their family size. So I think that's more of what it's all about. And one of my major reasons for disliking so much the Supreme Court decision in the Dobbs case is it totally ignores concerns about what are the preconditions of women's equal citizenship? What are the preconditions of the ideal of tolerance for people who are different from yourselves? What are the preconditions of good health and good public health? They completely ignore all of that. And I tell you, as a Black woman, knowing that the implications of the Dobbs decision was that women in Mississippi could not obtain an abortion in the state of Mississippi, to me that is a huge tragedy. And it's all the more tragic because Justice Clarence Thomas, who's also African American, felt no empathy with the predicament of the poor Black women in Mississippi who were going to be disadvantaged and harmed and even perhaps having their lives put in mortal danger by his decision.
And do you think, speaking to what you said earlier and your interest in autonomy, that autonomy goes out the window and it becomes prescriptive, life, liberty, and the pursuit of happiness, the right sort of happiness, the right sort of liberty to do the right sort of things as dictated?
Yes, and unfortunately, we have to always keep in mind that our Constitution, even the most noble language of our Constitution, was never at the beginning intended to cover everybody. It wasn't intended to cover women. It wasn't intended to cover Native Americans. It wasn't intended to cover Black people on the same equal basis. And so it shouldn't be surprising to us that even now we're struggling with constitutional interpretations to get us out from under the tradition of interpreting our Constitution to benefit some and not all. It needs to grow to be a document which is seen to benefit everyone, not just some people. And although I can understand how people might say, oh, well, today, there's no stigma attached to unwed pregnancy. There's no, there are social safety nets in place to help, food stamps, Medicaid. There's no reason, adoption. but a lot of that is just besides the point. But some of it is very much on point. And take the adoption argument, for example. I happen to have 2 children by adoption, and I can tell you that it is not easy for women to place their children for adoption. It isn't like you have a baby and then suddenly you can easily just give it away. It also isn't the case that after the adoption, you stop having a psychological interest in the child's welfare. So it's not easy to place your child for adoption. And also, it's not easy for some children to be adopted. My children are mixed-race kids, and it was damn hard for mixed-race kids back in the 1990s to be adopted by Black families or white families. So let's not assume that it's easy to adopt in terms of the mother, nor is it easy to be adopted if you're a child of color or you have a disability, as many of the babies who are going to be placed up for adoption will be minority babies, because there's not a huge market for Black and brown babies or disabled children. It's sad, it's true.
And that reality, do you think that it's when Roberts, wrote his decision about Shelby County and we didn't have to protect or look at voting rights anymore because it all had arrived, and they're just blind to issues, and when they say Black Lives Matter, they say, oh, that's old-fashioned or something. I mean, they seem to be 2 different worlds they're living in.
We really do sometimes seem to be living in 2 or more different worlds, which is why I think we have the division that we have right now, because some people are absolutely convinced that the need for affirmative action is over, the need for abortion is over, the need for any talk of race-specific remedies is over. We're now an egalitarian country. But you know what? If you talk to men in their 80s, as I did a couple of nights ago, I had dinner with a delightful elderly man, and he actually said that, well, when we grew up, everything was meritocracy. And I'm thinking, oh my God, this is someone who grew up before the Civil Rights Act, who doesn't realize that although he grew up in a nice, wealthy family, and all around him people seemed to be happy, and it looked like a meritocracy on the surface, that scratched a little bit deep, and he didn't have any, Black classmates, and he didn't have women who were, his college professors and his law school professors. So I mean, so that it's people don't necessarily see that we haven't arrived yet, and I don't necessarily blame people for not being able to see it, but the job of people like me, and I hope you, Professor Boylan, is to help people to see beyond what they can see on the surface of their own lives.
Yes, they have their own twin Earth, and that's it's not one that a lot of other people have lived on. They've kind of lived on it in themselves, and they've partially imagined it too. It's got Beaver there, Leave It to Beaver, and it's all kind of imaginary, and even Leave It to Beaver probably never really existed either. People love to make up their twin Earth, and they want to live there in their minds.
When we were kids growing up, and my family's from the South, my father was military, so we grew up on Army bases mostly, but we lived in this little bubble world where we thought we were just like the Leave It to Beaver family. We didn't realize that we weren't like, the Donna Reed family. I'm dating myself, but, we saw TV, and TV made us believe that we were equal because we saw a family, a mom and a dad, and a mom was staying at home and a dad went to work, and that looked like our family. And so it took a long time actually for me to understand that the pressures on my family were very different than the pressures on the mythical families that we saw on television and that exist so much across the country.
Yeah, and even today, it's people are trying to figure out where they're living, and they even are trying to be very prescriptive. If the world isn't the way they exactly want it, they say, let's ban books to say anything different. Let's maybe ban movies and television shows next, and control with keywords maybe how social media operates, and then it'll all be fine.
Michael, I want to quickly mention another pending case that we haven't talked about. There's a case pending in Texas in which a right-wing Christian group, Alliance for Freedom, is seeking to have the Texas court declare that the FDA, Federal Food and Drug Administration, lacked the authority to approve mifepristone, one of the two abortion drugs. It's an extraordinary effort to claim that the Federal Food and Drug Administration somehow illegitimately approved a drug in the year 2000. That drug needs to be taken off the market, at least pending this litigation, take perhaps forever, and therefore women be deprived of what has now become the most common means of abortion. Back when Roe was written, aspiration abortions and surgical abortions were the norm, but now the abortion pill is the favored type of abortion, and this medication abortion is a very safe and convenient way to obtain an abortion, and that's why the right wants to try to undo the legitimacy of these drugs. But the right is fighting on all fronts, and I think that the left and the progressives and the public health community and the medical community need to be fighting equally hard in the opposite direction. This is not, pregnancy is not safe for everybody. Babies, there's infant mortality, there's maternal mortality. It's not a good social reality for folks to have children that they don't have the ability to care for or don't want, and we need to preserve the right to obtain medically safe abortions across the board.
Yeah, and my daughter, who's a doctor, told me that it's a standard use for miscarriages, which 1 out of 5 pregnancies become miscarriages, and it can actually save the lives of the mothers to take this drug or have an emergency DNO, which people aren't taught anymore in medical school because they're afraid that people might call it an abortion and that they'll go to jail. It's there are other procedures that need certain skills too, and by throwing the baby out with the bathwater, they're going to increase mortality.
I had the pleasure of being on a panel at the American Philosophical Society a couple of nights ago with Donna Shalala, who's a former Secretary of Department of Health and Human Services and also former president of University of Miami and University of Wisconsin. And Donna was talking about the importance of our trusting in our doctors more and freeing our doctors from the threat of being punished for simply doing what they know is in the medical best interest of their patients.
Yes. Well, thank you very much, Professor Anita Allen. It's been a real pleasure talking with you this afternoon.
Thanks so much for having me on your program, and I look forward to doing it again, maybe sometime in the future.
Yes, I like that. Okay, take care.
Thank you.